exceptional families. Today, our webinar is dispute resolution options in early intervention and early childhood special education, birth through 5. Our guest is Tiffany Kell. She is the mediation program coordinator with the William H. Bowen School of Law Legal Clinic. She is responsible for implementation, contract negotiation, and promotion of the grant-funded mediation program serving Arkansas. Through these various projects, she works closely with the mediation clinic students through experiential learning opportunities and has with her a wealth of knowledge.
Thank you.
With all that being said, it's my privilege to introduce Tiffany Kell.
Thank you. I appreciate it. Thanks for having me. It's good. I wish I could see you all, but it's good to see you and get to know you. And I'll have my contact information at the end of this. And I welcome anytime you have any questions or if anything comes up, just let me know. And I'll be going through this sometimes at warp speed, but I hope to have some time for questions and answers if we're able to do some of that. And just let me know. So we'll dive right in. Let me share my screen here. And we will get it going. All right, let me see if I can, here we go. Okay, I hope it's in PowerPoint mode now where you're not seeing everything at once. But I think this has been covered. I work at the law school. So within the law school, we actually have a law firm. And within that law firm, mediation is part of it. So that's kind of the setup there. We handle Part B and Part C, so ages 0 all the way through 12th grade. We do the mediation, special ed mediation, and facilitated IEP and family service plans. So that's kind of what we do. So it's completely separate from the ADE or any school. So just kind of want to let you know the setup. This is kind of just a brief info about how it all began. It began with the reauthorization of IDEA. So it was a formal law that was introduced, and states are required, they're mandated under federal law to have both Part B and C a mediation aspect. So it's all in statutes and regulations. So just kind of wanted to let you know how it came to be. Like I said before, we handle both at the law school, and they're by grants from the Arkansas Department of Human Services, Divisions of Developmental Disabilities, and the Arkansas Department of Ed. So we're very fortunate to be able to do the ADR program for these 2 different types at the law school. All right. So the first part, we're going to talk about due process because this term is thrown around a lot. And I'm specifically talking today about due process as it relates to special education admin law, because it is a very different definition legally. But when we talk about due process, we're actually talking about resolution options, right? And then more specifically, it is an administrative law hearing procedure. So mediation, facilitation, state complaints, all of those are available to parents and to schools. But they do not get in the way of your due process rights. So you'll always have that ability to have a hearing. So I just wanted to make sure that we're all clear on that. And like Raven Hawkins, who's great, put in bold, parents have the right to disagree. So they have a right about how they can settle disagreements with their children. And that's what we're going to talk about today, all these options. As you can see, I love graphics, and due process hearing is in the middle, so it is the most contentious of them. I've seen this laid out as in a linear way as well, but you'll see their facilitation, and that's probably the least contentious. So you have these conversations that are ongoing. You have IEP meetings and IFSP meetings throughout. And then if you need a neutral to come and run a meeting, that's a facilitated meeting. A little bit further along, and we'll talk about when to use those, that you also have the option of mediation and state complaints. You have all these resolution options available to you. All right, here's a little bit of the difference. So who can request? Any organization, right, under state complaint. Then you see the due process hearing, who it is, and then for facilitated meetings. So you can see what those are. Who decides? The state agency officials, an impartial hearing officer, and then you kind of have the ability through mediation and facilitation, you mutually come to an agreement. You can see the timelines. It's very short for mediation and facilitation, and it gets longer depending on what you're looking at. The financial cost is also listed. It can be very expensive, and we'll talk about that more because I actually did some research on Arkansas and kind of what those costs look like. So you can see the different costs that are involved in these procedures. All right. So we're going to mediation. It can be requested at any time. So when I first came on board years ago, I think the only time we ever heard about mediation being requested was after a due process hearing was filed. So it was because it's mandatory then to at least offer that resolution conference or a mediation. So that's the only time. Now, I think that it is offered when people come to an impasse, but you can request it at any time. It's just an opportunity to get into a room. And sometimes, and we'll go into this a little more, mediations are used at a time when maybe there are communication issues and maybe it doesn't go into the IEP, but agreements need to be made. And so we can put that in a contract form. The contract is legally binding, right? And it's enforceable in any state or federal court. It's signed by both the parent and the representative of the lead agency. You've got criteria for a mediator, and we'll talk about that because in the state of Arkansas, our standards are extremely high compared to other states. So that's something we're really proud of. And then we talked about the bottom one also, changes optional procedure to offer or not require the meeting. Lead agency must select the mediators at random. So that's something that we take care of. It's voluntary and confidential. So what happens in a mediation stays in a mediation unless it's part of that agreement and it comes out. It's a trained and impartial third party. That's very important. And it's a mutually acceptable solution. It's not always a, hey, we both feel great about it. But it works, It's okay, That's usually a win for a mediation. We talked about confidentiality, but there are some differences and different ways that confidential will be pulled out. That's a written signed agreement specifies responsibilities of each party, and those who need to know are involved with the IFSP or IEP will have access to this agreement, right? So any agreement that comes out of there will be shared. There are exceptions to confidentiality. One is a threat of harm to yourself or to others, child abuse or neglect not previously reported, which I know sounds awkward, but we also do a lot of dependency neglect mediations in different ways. So this is all part of the mediation rules and laws. Our parties are given written consent that they agree with this. Communication is public, and then if disclosure is required by statute, those are the exceptions. It's legally binding. We talked about that in any state court or federal district court. And we talked about the confidentiality. So we talked about the effects on due process rights, because a lot of people say, well, I'm going to go to a hearing, or if I do mediation or facilitation or even file a state complaint, then I'm not going to be able to file a due process hearing. And that is absolutely not true. There are no effects. It shouldn't delay or deny any parent's right to due process. And parents have that right to due process through their children. So at any time, parents may request an impartial hearing before, during, or after mediation. All right, so the guiding principles to mediation are just honest communication. The law and statute requires a good faith effort. No one dominates the conversation. There's not supposed to be a lot of blame. And the whole focus is to listen to understand, not to find fault. Something that comes up quite frequently, and that's why I put it in here, is that people say, well, when you understand, we don't always agree. You're not supposed to always agree. But the point of it is to be able to communicate so that you understand where everyone is, where each other are sitting. All right. It's a guided negotiation. And there's roles of a mediator, right? The big overall reaching goal is empower the parties. So when I am mediating, I definitely consider the parties, but my focus is on the process. So I have allegiance to the process. So that's different than facilitation, which we're going to talk about. So when I mediate, I am completely focused on that process and how to maintain integrity of the process. So I need to remain impartial. Everyone needs to remain impartial if they're a mediator. I act as an angel of reality. So sometimes that might be in a big group setting, but oftentimes that's done in a caucus. So it's a private meeting outside of the mediation, which can be called at any time, and it has another layer of confidentiality on top of that. A mediator you sift through a lot of information to focus on critical issues and help people, I call it grouping, but help them group it into different pots so we can understand, and it's easier to process at that point. Frame the discussion. And then also validate the parties, their feelings, and kind of what they're going through, their emotions, and what their agendas are. Can I trust that guy, the mediator? So knowing a little bit about the mediator is pretty important, I think. Oftentimes we get calls from parents and they'll say, well, I've already dealt with the school, or I've dealt with, that program administrator. I don't want to do that again. And that's understandable. So at Bowen, we're not affiliated with anyone except for the law school. In Arkansas, you may not be, or any federal, you may not be, or in Arkansas actually specifically, because in other states, Department of Education does have mediators. But in Arkansas, they may not be an employee of DHS or the Department of Education. They may not have a professional or personal interest that creates a conflict of interest or interferes with the objectivity. At Bowen, we actually send out something called an at-a-glance, which is a kind of a meeting agenda. On that, we'll list everyone who's going to be in attendance. The point of that is because, especially in Arkansas with really small schools and small areas, oftentimes there might be a conflict. Perhaps we have a law student, because we do have law students observe these meetings as part of their credentialing program at the law school and classwork. But they might know a principal, or there might be a parent that knows them, or it might be that a mediator knows a family member. So we try to list everyone so we'll know if there's any conflicts, and we can take care of those in advance. They're trained professionals certified by the state of Arkansas in at least one area of mediation, and we'll talk about a little bit of what that looks like. Federal law, which is different than other types of mediation, actually requires that the person mediating be knowledgeable about IDEA law, regulations regarding early intervention, special education, and related services. So they need to be knowledgeable, not an expert, but knowledgeable. This is kind of what we lay out. So they're certified by the Arkansas Alternative Dispute Resolution Commission in at least one area of law, or one area of practice, sorry. They have to adhere to the ethical practice of mediation. So we have our own guidelines. In order to do this, so they're already certified in one. On top of that, they have to observe at least one special education mediation or co-mediator facilitate, both on a pro bono basis. They have to receive a minimum of 2 hours of continuing education in special ed, in addition or part of the ADR Commission requirements, and complete a 16-hour special ed training course that we actually conduct. And then any other trainings that we consider mandatory, or if First Connections or Department of Ed is putting on something, then we'll have it mandatory that mediators attend those so we can keep up to date. It's available for any student under the umbrella of special ed, or any student who has been denied status. So this doesn't really affect early education, but it might when you get into kindergarten a little bit. If you have a student that has just a 504 and there is a question of whether or not that student needs an IEP, then we're able to facilitate that meeting or mediate any issues. Mediation may be requested any time when a dispute has reached a point where parties can't agree, so an impasse, so they're not able to come to an agreement. And then we talked about IEP meetings. It's any time there's an IEP meeting where parties feel a third party might be advantageous. School staff, educators, parents, guardians may all request a mediation or IEP meeting. And we've got request forms online, and we'll talk about that at the end. So a little bit about this. Like I said, I'm a visual person, so it's easy for me to understand. So you've got all students, which is the gold circle, right? And inside that you have 504 students, and inside that is an IEP or IFSP. So just to kind of keep it, or I guess IFSP wouldn't apply if you've got a 504, but when we're talking about 3-year-olds and older, which we've got some 3 to 5 on here, and then especially when these kids get past that age, when you get into getting ready, maybe after high school, going into college, you really need to focus on making sure that student does have a 504 in place, because that's what you use in college. So I know that's way past this, but it's all part of the big picture and understanding how it all works. All right. Let's see if we get into a little bit. So an IEP versus a 504, and hopefully we'll be able to give you these. I know it's being recorded, so if you need this slide set or anything, just let me know, and I'm happy to provide it, because it is a lot of information. So an IEP is an ability to learn, where a 504 is access to learn. So this kind of divides it out, if you can get it straight in your head as you're going forward, and keep, just remind of why you would need one, or why you might need both, because I know it's a hot topic, but each each can be helpful, and even sometimes you can have them concurrently, which can be helpful as well. So IDEA, what's the law that controls special ed, your IEPs, and then Section 504 of the Rehab Act handles 504. So there are different laws that apply. A child has one or more of the 13 specific disabilities, right, under the IEP. And then your 504 can be a child with mental or physical impairment, which limits one or more of life activities, right? So keep that in mind. Ooh, my slides messed up a little bit down here. Sorry about that. I think it's important to let parents know you should write a request for assessment letter to special ed. It's not needed, but it's always good to put these things in writing because actually Raven and I were talking earlier today. It's important when it comes time to the timelines, the federal timelines that are involved for both. So you'll want to make sure that that's all put in writing as a safeguard. Creates an IEP team, right? It's very specific. It's laid out by federal law. So you've got your members of the team. 504 is really gray and fuzzy. Sometimes that might be the person on the team. It might be a vice principal that leads it. At some schools, it really just depends on who that is. So I wish I could be more specific, but I can't. You just need to know who that person is and make sure that you're meeting with them often with your child. I mean, there's different rules and regs, but just like an IEP meeting, you can ask for a 504 meeting at any time. What do they create? So we know what the plan must include, right? It's a present level of academic and functional performance, annual education goals, right? Services the child will receive, when they will receive, how often, make sure it is very specific. A list of accommodations, any modifications, how the child will participate, and how the child will be included in general ed and school activities. A 504 is a lot looser. So the specificity sometimes is driven by the parent, unless you just have an amazing school. And there are, I mean, I've seen some 504 plans out of school districts that they're really well put together, but it's a little looser because you don't have the same federal laws backing it. It generally includes specific accommodation supports or services, the names of who will provide each service, and the person responsible for ensuring this plan is implemented. All right. Parent notice, you've got to give parent notice, change of placement, location change, but not necessarily a change in placement, and then we'll talk over suspension, which is usually the older children, and stay put rights. Although kindergartners, my goodness gracious, but it's getting better, of course, with the new laws we have in place. 504, you've got to give parents notice for an evaluation and a significant change in placement, but it doesn't have to be in writing. So you can tell it's a lot grayer. It's revised at least once a year, the IEP or IFSP, and the student must be evaluated every 3 years. That's a little different with the early interventions. We'll talk about that a little later. And 504, the rules vary by state, reviewed once a year. So as you can see, it's really loosey-goosey. And in fact, sometimes I've seen several districts where it's not even reviewed once a year. So I think as a parent, it's just really important for you to stay on top of that. And as your child changes, a 504 will change, right? So you might not have the same goals that you do with an IEP, but they're definitely growing and learning differently and progressing. So just keep that in the forefront as you move forward. Students must be assessed in all areas of suspected disability. And if eligibility assessment includes a 504 assessment, request in case the child does not qualify, and it just saves precious time. So just little hints I try to put forward for parents. And of course, that's the older kids for the most part, but you're on here. A snapshot, right? Free appropriate evaluation assessment. These are the hot topics. Free appropriate public education, individualized education plan, and all the acronyms, LREs, and they are just thrown at you. I try to do a better job, but you'll hear my entire presentation throwing these acronyms around in abbreviation, so I apologize for that. And you guys will be professionals in all of this as well and start throwing them around. It really takes such effort to stay, okay, least restrictive environment. And then also parent and student, if appropriate, participate in the decision-making process. I am a fan of having students in IEP meetings or IFSP even as soon as possible and often. I mean, my goal would be for a middle schooler at the end of middle school, if possible, to be leading some of those IEP meetings, definitely in high school if they're capable, even with parental support, but having a voice at that table. It's kind of the old public health, nothing about me without me. We are firm believers in that, and I have different ideas about ways you can pull a child into a meeting, whether that is just by invitation when they're young about who they want in their meeting. But I think it can be very empowering for a child to know that people are meeting about them and they have an entire tribe on their side, especially when they get into mainstream education. And then, of course, we've got procedural safeguards, which we're going to discuss today. That's my 2 cents on bringing kiddos in. We talked about the IDEA, and it's designed to meet their unique needs and prepare them for further education, employment, and independent living, right? We talked about Part B, child find, manifestation determination. We'll talk more about child find a little bit more, but I want to make sure that you've got this in your slide deck because I think it's very important. Oftentimes, I mean, we very rarely have any mediations. We've maybe had a couple of facilitation requests for the early intervention. They do such a fantastic job working with families for the most part and wrapping around them. When you will see the hiccups are, we get a significant amount of cases in kindergarten, middle school, and then also going into high school. So it's like the more teachers that are on board, the more people that are involved in a child's education, it really stretches things. And it requires a great deal of communication and collaboration to all stay on the same page. So I think a lot of times they've got this great group of people working with them, and then they hit mainstream education in kindergarten, and it's a very different environment. So sometimes things fall by the wayside, or if they did apply and they were able to have an IFSP that no longer applies to when they're in school in kindergarten or even pre-K. So some of those kids get left behind. But there is a duty of schools to find children that includes any children suspected or having a disability and needing special education, even though they may be advancing from grade to grade. That has nothing to do with it. It may impact what's needed for them, but that doesn't mean that you shouldn't identify them. All right. A parent's expressed concern in writing to a teacher or the administration, right, would trigger this. A parent's request of evaluation, behavior performance of the child demonstrated a need for services, right? So oftentimes we see cases when the kids are a little older where they maybe have been suspended for multiple times in kindergarten. And it's basically the same type of behavior. Well, that should trigger child find. So a lot of people don't think about that, but if it's the same situation over and over, that should give you a heads up. Even if there's teachers talking in a lunchroom and they go, wow, that Johnny sure is hyper. He's just all over the place. That should trigger child find, at least an evaluation if that child has not been evaluated, to make sure that you're able to wrap around that child and meet their needs. If something is predictable, it's potentially preventable. We see most issues at the law school with behavioral. And you've got lots of supports in the state. They're not always utilized like they should be. So sometimes there isn't a BIP, a behavioral intervention plan, and there hasn't been an assessment done. So as your child moves through school, make sure that you're aware of this. And there's functional behavioral assessments that should be done, and BIPs are required when the LEA, the parent, and the relevant members of the child's IEP team determine that a student's conduct was a manifestation of his or her disability. It's very important. These things are not set in stone and never looked at again. It should be a working document. There should be data associated with it. If you've implemented a new BIP, a behavior intervention plan, you should look at that every couple of weeks, right, to make sure that it's working. The FBAs can be fantastic, where they talk about the ABCs, the antecedent, the behavior, and the consequence of that. The whole idea, and I'm just a champion of this because I think I'd see it down the road. If it is predictable, it's preventable. So if you know that's how this child reacts or behaves, then let's put things in place where it's more successful for the child and the teacher in that classroom and all the students, right? That's the whole idea, is getting in front of it. Change in placement, a lot of information here. I'm going to leave it for you because I don't know that we need to go through it all, but there's a lot of information here about violations of school codes. And like I said, it's usually later on when this will affect you, but it's something for you to have in your back pocket. Positive behavior intervention supports. Again, this is the number one thing that we see in Arkansas, and I think I know it's across the nation. When we actually have mediations and facilitated IEPs, it's regarding behavior in the classroom. You're supposed to have positive behavior intervention and supports. In Arkansas, we still have districts who use corporal punishment. That is not appropriate. And I'm pretty vocal about that. So it might be legal, but if you have a child with special education needs, if you have a 504, you really you have to look at FBA and BIPs and make sure that the positive behavior intervention supports are put in place. What that looks like can be very interesting. So maybe sometime we'll have a chance where we can actually give some examples of some that I've seen that they're saying, well, it's positive behavior because I'm not spanking them. That's not really positive behavior support. That's you restricting your behavior. So to think about positive behavioral supports, it's ways you can help change the child's behavior in a positive way so that you're rewarding them. Not necessarily, it doesn't even have to be different kinds of rewards. And I'm meaning, just little carrots, but it's definitely not, the consequences aren't so severe where you're actually, hitting them or secluding them. So it's pretty specific, and you go through, but just make sure these things are put in place because it is very important for a child, because the whole goal here, and I talk to parents all the time, we want to help create a love for learning, a joy, right? Because that's what gets you through when it gets mundane and tedious later on, right? Because we've got these great math scores in 3rd grade and then they just plummet in 5th or 6th. And I think some of that is just because kids are bored or they've gotten to where they don't feel like they're successful in school. So that joy and love for learning has changed. And that's something we have to do better as a society in America, is help grow eager learners. And part of this is making sure that we create a successful environment for them. Off my stool now. Sorry, I get kind of excited about the behaviors. Manifestation determination. So if the parents of a child with a disability, the LEA, and the relevant members of the IEP team cannot reach a consensus or agreement that the behavior was not a manifestation of the disability, then the agency must provide determination, provide a parent with a prior written notice, right? There's procedural safeguards by requesting a mediation or a due process hearing at this time. A parent also has the right, and you'll see this throughout, to file a state complaint alleging a violation to the manifestation if it didn't take place. There is a state put rule. It's pretty important. Federal law requires, absent some agreement to the contrary, the youth shall remain in his or her current education placement pending a completion of any due process proceedings, court proceedings, or appeals. All right. Responsibilities of all participants: participate and provide input. And if you've ever been through a facilitated IEP meeting that Bowen does, or IFSP, or a mediation, it's all not mediations, but any of the IEPs or IFSPs are agenda driven. And sometimes, depending on who's in the room, we will even kind of task different parts out. For example, if you're bringing a child into the room, we want to make sure that we give them something to talk about that's comfortable for them. So we'll work with the parents or some of the providers about ways to bring that child's voice in. Sometimes it's done via video if they're uncomfortable, or when they're older, they can write a letter. There's just different ways to do that. Also, I think it's really awkward when you get older and there's always the vice principal, or usually the vice principal's in the room because it's behavioral focused, and you just want to give them something to say. I think it feels awkward when you have people in the room and they don't know how to contribute. So to plan that in advance, I think, creates a more successful meeting. So giving everyone something to bring out. So I really like, for if it's a behavioral motivated mediation or facilitated IEP meeting or FSP, which doesn't, like I said, doesn't really occur that much, but the IEPs do around behavior, to give that vice principal maybe the characteristics of the child that are great, the successes they see at school, the strengths. So we always try to come from a strengths standpoint, and that seems to work well. Because maybe the vice principal knows the strengths, maybe they don't. The thing about it is, when they have to plan and present in a meeting, then they'll do some digging. And that can be really incredible for a student who often goes to that person for consequences of behavior, to actually have them say some really positive things about them in a room. So you'll assist everyone in the meeting, assist in information development, identifying issues, identifying potential solutions, and review the case plan with long-term perspective. And I try to keep that in mind. Sometimes when you get confrontational, it's easy to think about what you want right now, but more difficult to think about long-term what you want this relationship to look like for your child, especially in smaller districts where you don't have a lot of ability to move schools or different teachers. You want to think about, okay, what can we put in place now that will help this child thrive, not only tomorrow, next week, next year, 5 years from now, 10 years from now? What do I want my relationship to look like? And that's something that we really try to focus on. How to prepare, gather appropriate documents. This is where TF, I'm going to say it wrong, but Shelby Knight's group, Centers for Exceptional Families, really does a great job of helping parents feel secure about how to prepare for meetings and how to have everything in an organized fashion to be able to advocate for your child successfully for years. What I would ask you to do is make sure you've got the appropriate documents that you want to discuss, make copies for the mediator and other parties before you come. It's been kind of crazy via Zoom because we're unable to share those. Sometimes we do, but usually the law school has them all and we'll show them up on the site because it's just easier. Outline the issues you wish to discuss, and this is all done in advance. Usually the mediator or someone for Bowen will talk with them, actually the different people in the meeting to make sure we have a clear idea of what's going to be discussed. Write out questions that you want answers to and remain open to ideas which differ from yours, right? So we talk about BATNAs and WATNAs, the best alternative and the worst alternative. Try to keep those in mind, what it would look like, what you're willing to negotiate. Put aside your personality conflicts, which is really hard, right? But I think it's helpful when the child's in the room because number one, it promotes better behavior from everyone for the most part. But it's also important to keep the focus on the child because that's what we're here for. And I think you'll see that with neutrals. They're able to do that, even with the strained, right, relationships that can happen. And it's normal. I mean, you're talking about your child. It's impossible when I go to school to meet about my children for me to be completely neutral because it's hard and difficult to listen to people have things they need to tell you about your child, unless it's done in a way that's strength-based, because you might even know some of those things, but it's just very difficult. So I think that the personality conflicts are normal. I don't want to say, oh, just put them aside, it's easy. No, I mean, it's something I think I am consciously aware of when I'm in a meeting about my children. It's something you really have to work at. And think of what you want. What do you want from the mediation? What do you want from the other party? What do you think the other party wants from the mediation? Think about that. And what do you think the other party wants from you? And what are you willing to do? Planning is everything for mediation and in any meeting, any meeting at all. Who attends early intervention? Parents, guardians, service providers, early intervention program personnel involved with the child. Someone from DDS with decision-making authority if they're needed. Parents may be accompanied by support persons. I always encourage someone to bring someone else. It is impossible to be in a meeting, talk about your child, take notes, think of questions, and listen all at the same time. It is impossible. So we all get better at it, but it's always better if you have someone there with you to help you, right? To help even take notes. Can you take notes while I'm thinking about this so you can be more in the moment? Attorneys may not attend. Arkansas, I think, is the only state left in the United States where attorneys are not allowed in special ed mediations. It used to be, I think, Arkansas, Pennsylvania, but I think that they've pulled that back. So not in mediations, but in definitely any kind of facilitated meeting, attorneys are involved. And I say the more the merrier. If you've had relationships or a different classroom that really worked well for your child, and this year it's just been upheaval and crazy, and that maybe a lead teacher or a provider is willing to attend to talk about what worked and how it worked, I say bring them in. If they've got the time, it's just helpful. Everyone's goal should be on the child and how to make things work best for them, but how we get there is sometimes debatable, right? And that's where it can get really gray and hairy. So knowing what has worked and getting different perspectives is really important, and it's just crucial for success. Special ed mediation. So you've got the same parents, guardian, teachers, other interested persons with knowledge of the child, someone with decision-making authority. You absolutely have to have someone with decision-making authority. Sometimes that's the LEA, sometimes it's a superintendent. It really depends. Parents may be accompanied by support persons. Like I said, I always give them our advocacy centers because it's important for them to be able to reach out. Attorneys may not attend. In the same situation, the more the merrier. A lot of parents might want to leave out difficult members, or I don't want to say difficult members, people that they have difficulty with. But the problem is that if you don't bring the people to the meeting that are involved in the meeting, they will break it down the minute you leave the room. Right? Does that make sense? And it's easier sometimes to think about things outside of education. So if you're going through a divorce, right? You don't want the, you don't like the girlfriend, but the girlfriend has a lot to do with the ex-husband. And when the children are there, you've got to have them in the meeting. The reason why is because that's the first person your ex-spouse is going to go to after they leave an agreement, and they will tear it down unless they're part of it. So that they don't have to be there the whole time. I know that it gets very difficult sometimes, but even teenagers coming into IEP meetings when there's been a lot of harsh feelings between parents and teachers, I say we can bring them in at different times if you don't want them to see the nitty gritty, but then, we need to have the person that's going to be able to make this thing work. And sometimes you kind of have to grovel around a little bit and sit with the upset to come out on the other side. Great odds. So it's pretty incredible. In most states, 85% of all special education mediations reach an agreement. Ours is actually higher than that. And I think it's because of program fidelity. We are in an interesting situation where we have students observe, and that creates, I think, some feedback for the mediators and facilitators. They're very comfortable with that feedback. We also have a few things in order where we get participants' feedback at the meeting, and we can do follow-ups. So sometimes it can be as soon as 2 weeks, or it might even be 3 months later. We'll follow up if a mediation's happened and there's a contract that comes out of it. Because as we teach the mediators that work for our program, we're not as concerned about an agreement being reached as a good agreement being reached, one that holds water. Right? One that doesn't sink the minute something goes awry. So that's more important than having an agreement. We want one that works for parties. And the best way to do that is to follow up with parties. Let's see here, the different goals. You've got an objective to improve and develop the IEP, IFSP, and the others to help parties negotiate a resolution of defined dispute, right? The timing, it usually intervenes when parties realize the discussion will be difficult and complex. So for parents, this might be that you feel like you've said something 3 or 4 times, or you don't really feel like they truly understand your child and how they're working as a student. For schools, it might be that you've explained something to a parent a few times and you feel like the relationship is being pulled. You want to try to ask for a facilitator to come in, because just having a neutral in the room can help ease tensions. So the earlier, the better. And I think people are really open to it. At the beginning, when we first started this, I used to hear all the time, I hope I never have to call y'all. And I thought, wow, that's so disappointing, because you would rather call us than go to court. Do you know what I mean? For everybody involved. And then I think, gosh, it almost seems like the people that call us a lot, the schools or the areas that call us a lot, are the least, the ones that need us least. But that's their habit. They're into good communication. They are dedicated to collaboration. And so with anything feels a little upset, they're like, hey, it's a free service. It's already sponsored. Bring them in. Let's do this. So that's the timing. For mediation, interventions usually after the parties have already had conflict. And it's an impasse. You're really trying to bring parties back together. For facilitation, the method, the entire group stays together for the most part. I've maybe caucused once or twice ever in any kind of facilitated meeting, because my allegiance is to the group. As a facilitator, my job is to help a group work better together. As a mediator, my object is to stay true to the process. So it's a little different. So in a mediation, a group stays together or works with a mediator in caucus. And a caucus is a separate meeting outside with an extra layer of confidentiality. The role of a neutral is to help the meeting process, right? So help that group work together. The role of a neutral is to help with collaborative problem solving. The outcome is an IEP or IFSP developed or not. And this is tough for a lot of people, because they try to do mediations in facilitations and vice versa. But to me, it's pretty easy. The outcome of a mediation is a contract. It's a written agreement, which we call a memorandum of understanding. It's an MOU. Sometimes we'll attach an MOU to an IEP, but I think that's a mediation, and it's by federal law, that would be considered a mediation with an IEP attached instead of the other way around. Agenda driven, right? With IEPs and IFSPs, I told you it's very specific and agenda driven with different people tasked with items to discuss. And with mediation, it's issue driven. They're both for conflict. Well, one's conflict prevention, the other's conflict resolution. And then 1.5 hours for any meeting, any facilitated meeting that we do. We do 3 hours for any mediation, because it's just more intense. And it's usually hurt feelings involved. And you've got to get through that. You have to understand how that came to be and try to map out a different way of communicating so that you can move forward, if that makes sense. Gosh, I wish I could see you guys. We talked about this. Mediation is usually positional. Facilitation, hopefully not positional yet. You can see I'm trying to be excited about that. Mediation is required by law. Facilitation is not required by law. It's something that Arkansas does on top of. And I think, I can't remember when we put it together, maybe 8 years now, 7 years. It's been in force a while, and we do many more facilitations than we do mediations at this point. Like we said, again, attorneys may not attend a mediation. What they can do now is we can have a meeting and we can stop and you can talk to your attorney on the phone or in a different room. We've done that. They just might not be in the meeting at that time. So it's not that you cannot, visit with them and get their opinion. You absolutely can get their counsel. Attorneys may attend any kind of facilitated meeting. Focuses on repairing relationships for mediation, and facilitation's opportunity to kind of grow it, right? Usually more complex for mediation. Like I said, it's some hurt feelings, different things. Facilitation, misunderstandings, and just the beginning. They're both voluntary, though. You may not require anyone to go through a mediation, special ed mediation, or facilitation here. This is just something I put together because I think we all shoot for collaboration, right? That's where you see the magic happen. Cooperation, we do this a lot. So even driving to work might require cooperation, right? You're sharing information on lane changes, that type of thing, without even speaking. When we used to drive to work, I'm just sitting in my house. So even maneuvering over who's grabbing the first cup of coffee in your house, whatever. Coordination requires longer term effort, right? Some planning, division of roles, some shared resources. But that last column, that's what we're all shooting for at every point we can when we're working with children, and especially, which is my favorite area that we deal with at the law school, because I think you can see change happen almost immediately. So it's very rewarding to mediate and facilitate these disputes or cases. And just, I think it's such a success. I mean, I'm from Arkansas. So to see when we can bring joy to a child with learning and help parents feel more at ease, that is a win. So I think that you get that when you have everybody in the room and it kind of collaborate. You're able to collaborate. And you all have been part of teams that really work. This is when teams really work. So if we're all shooting for that, I think we can get there. It's a win, and it takes hard work to get there, right? Sometimes it happens, but usually with a lot of different players, and it moves all the time in education. You've got to be willing to kind of put in that work. All right, why would you? You want to help preserve the relationship. We talked that to death, right? We're doing this for years. It's not just 1 or 2 years, it's years. So we want to try to foster that and help empower children. It can happen at any time during the relationship. An outside party doesn't impose a solution. That's critical, because when you go to due process, it happens. Can talk about anything, not just those issues that can go to a due process hearing. So it's the time to talk about, I don't like it when you email me in the middle of the night, or, if a teacher's saying in the middle of the night and I'm expected to have a response and be ready to go the morning of. It could be that a parent's frustrated because they're not getting information on their child's behavior or how they're progressing. Are they meeting the goals? I mean, that's something that I think parents should be very involved in. You should know if your child is meeting the goals that have been set forth, and be involved on creating those goals, right? Because it takes a team, and you want to know what your child's able to do and how to get there. So you can talk about anything in these meetings, and people tend to keep agreements that they create. That's the most important thing. And that's why it's key to start bringing a child in early and often. All right. Worksheet lists the things. We talked about this. 2 realistic solutions that would work for you. That's just digging a little deeper. If you were another person, would these solutions work for you? Put yourself in their shoes, right? So I think it's easier for us to go, well, I'm not asking you to do everything. Well, I kind of am. You know what I mean? And that's okay. You just need to be able to put yourself in their shoes and try to come up with solutions and see if they would work for you as well. What are you willing to give the other person to get what you want? Think about that. What do you need from the other person to agree to give him or her what she wants? What do you want your relationship to look like next month, next year, 6 months from now? Keep that in mind. State complaints. Okay, this is not my forte, but Raven put it together, and I deal with state complaints under Part B in that a lot of times now, I mean, it's gotten, it took years to get to this point, but when someone lodges a state complaint, they are now given the option, would you like to go to mediation, or would a facilitated IEP or IFSP meeting work for you? But it's a formal written complaint. It's one dispute resolution option under the IDEA, available to any person or organization, who includes those from another state or people who are related to the child. That's important because that's very different than a hearing, a due process hearing. Anyone may file a complaint to notify the lead agency of an alleged violation. A lot of times when I see these, there's systemic issues that they see are a problem. Not more than 1 calendar year prior to the date that the complaint is received by the lead agency, right? These formal written complaints may concern one child or a group of children. So that's when you'll see a big systemic issue. We had a few come in when the dyslexia law went in place. The state complaint is sent to the state lead agency for resolution, DDS for early intervention 0 to 3, or the Department of Ed for preschool or school-age children. All right. The parent guardian, service provider program, or service provider related agency or other entity filing the complaint may choose to resolve the issues through informal meetings, which we just talked about, before writing a written state complaint without jeopardizing the rights to file a formal state complaint. If a state complaint is filed, the parties may still pursue mediation, facilitation, or a due process hearing to resolve the issues. If issues are resolved during the meeting, the parties should signify that in writing, right? All right, state complaint procedures. It must include certain information, a statement describing how a provider, program, or specific service provider, lead agency has not followed the requirement of IDEA. Facts that support the statement of the alleged violation, right? Dates, the more specific, the better. The desired outcome or action the person making the complaint would like, and the signature and contact information or organization. It's important. I know that the Department of Ed has these loaded up. I guess, Raven, maybe you can chat us and let us know if it's on First Connections, because it is very important to follow the rules of exactly what needs to be put in these, or they will be rejected, at least with Part B. All right, if the state complaint concerns a specific child or group of children, it must also include the child's name and address, a description of the problem, including facts relating to the problem. If the state complaints about a service provider or program, the name of the provider or program, if possible, the name of the specific service provider serving the child, and how that person or family or persons may have violated the child's family rights under IDEA. If the issue raised a formal state complaint are the subject of a current due process complaint, the investigation will be set aside until the due process hearing has been completed. If the issues raised in a formal state complaint were the subject of a prior due process hearing, the hearing decision is final, and the complainant, person filing the complaint, will be notified that the complaint cannot be addressed. All right, due process hearing retains state option to use either Part B or Part C, incorporates Part B procedures into Part C. C regulations with modifications include option of a 30 or 45-day time frame. They try to do it quickly. It's administrative law because they want to service a child and get them back in school. That's the whole point of this. Under Part C process, extension of a 30-day timeline can now be granted by hearing officer at request of either party. I don't know how it happens. That's the same in Part B, and almost all of them are being requested an extension. And I've heard the hearing officers kind of grumble about that because the whole point is to service the child sooner. And I think for the most part, I could be wrong. The last time I discussed it, which was pre-COVID, which, you think it's a month ago, it's actually been 9 months. But most often this is the parent's attorney requesting these extensions. So that's kind of important to know. It requires copies of transcripts, finding of facts, and decisions to be provided to parents at no cost. You can read these you can read the hearing decisions on the ADE website. I'm not sure what it's like. I don't know if you guys even have them in Part C. I haven't heard of any, but Part B, you can actually see them online. Read them online. Resolution process. The lead agency has 15 days to schedule a resolution session after request for due process. Timelines are very important. If the state agency does not conduct the resolution process within 15 days, the parent may request the hearing officer to begin the due process timelines. We are able to facilitate resolution processes, and we do them. If the state agency wants to conduct a resolution session and the parent refuses to attend after 30 days, the school may request that the complaint be dropped. Both parties may agree in writing to waive the resolution session and proceed to due process. That most often happens, I would say 99% of the time. Okay, here's my cost analysis that I put together for you all. So you can see a facilitation, hour and a half, $135. Mediation, 3. You look at full state complaint investigations, and these are low. I actually need to do it again. I think I did this one probably 7 years ago when I first started trying to see what the difference would be. But it's usually 2 people going out, and it takes them a couple of weeks. So you're looking at a minimum of $4,000. Attorney's fees for parents, about $20,000. Outside counsel for schools, another $10,000. Settlement prior to due process hearing is $23,000. Verdict costs might be up to $16,000. And then you've got insurance. What isn't always considered in here, the due process hearing related costs. You've got to get independent evals, subs for teachers, etc. None of this talks about just this emotional strain on schools and parents. So I think that's my responsibility, I think, at the law school, to talk about the different dispute resolution options, and then talk to parents about how each one might weigh on them. And then, of course, they should talk to their counsel, and their counsel should be very upfront with them about what this looks like, because it can be very difficult for schools as well as families. I will never be the person, and I've said it over and over again. Those of you who have heard me talk, hear me. I think there's always a place for litigation. It's just that, and sometimes that's your only option, depending on what you're talking about. But it is very difficult. So the earlier you can get on top of things and get them going, the better for everyone involved. All right. Do we have any questions in the chat? I think I've got just a few minutes left, so I timed it right.
Hey, Tiffany, this is Rhonda.
Yes.
I think if anyone, I like it better when they can actually talk. So I think that if somebody wants to ask a question, they can raise their hand and then we can unmute them.
That sounds good. Did you guys hear that? And I'll stop sharing so we can.
Does anyone have any questions?
Wow. It was a lot of information.
You answered everybody's question.
Right. They're probably going, what? I knew I had to fly through, and I apologize for it, guys. I really do. It's a lot of information.
Yeah, but that was a very good presentation. And I myself would like that email to me. So
okay, great. I will. I'll send it out because it's just packed with information. At the very end, the final slide, I actually put the timeline so you can kind of see it, because I think just knowing those dates, it's critical.
Yes.
Hey girls, this is Shelby. I want to throw something in here at the end. Tiffany, your presentation was really good and spot on, but also the importance. I just want to stress the importance of making that connection to your public school system. It is not the same experience that you're going to have in early intervention. It's not, and you've got to get ready for that. It's a very different neighborhood when you get to public school. So if we can help make that difference for that family, if we could help introduce them into the trust of that public school system so that they can get to know each other and build a relationship. That's what you've got to do to take care of these kiddos. You've got to build a relationship with your public school and learn to have a trust with them, learn how to communicate with them early on. I think that's the key. I mean, I do.
So yeah, I just just to tag on, I know we talked about it a second, but I mean, we see them in kindergarten. I mean, that's when we see
Yeah.
the most mediations, and it's just, it's
Yeah.
awful, right?
Yeah.
I mean, because we know things were working before that.
That's right. That's exactly right. And early intervention is so wonderful, and it takes care of the whole family. And then you get into public school, and I could share horror stories about our experience. And I thought they would treat my son the way they treated him in early intervention, and that is not the way it works.
That's right.
Yeah. So I think that is very important. Fabulous. Just fabulous.
Well, I'm not seeing any questions. I mean, if y'all want to type in chat, if you're more comfortable doing that, you can do that also. But I'm not seeing anything. If anyone thinks of anything, I'm sure you can contact Tiffany or myself, and we'll get you the answer to your question. But if we don't have any questions, then thank you so much, Tiffany, and First Connections. Raven helped put this together, and we so appreciate that. So if that is it, then I guess we will say goodbye.
Thank y'all.
Thanks.